I told you that shortly after your accident, someone from Cowboy Up hit a tree and killed two people, probably within 10 days or 2 weeks of this accident. And I'm glad that wasn't you. It was snowy on January 1st. I think this, I don't remember what the weather was in the other one. All right, next we have Cameron Doherty. This is file 2622SD, People versus Cameron Dale Doherty. Good morning, Mr. Doherty. You're here with your attorney, Mr. Paul Gibson. Also present is Matt Huff, who drew this assignment. Certainly the easier of the two from this morning. You pled guilty to impaired driving for an incident that occurred on January 1st. And Matt prepared the screening report. Mr. Gibson, what would you like me to know? I'm going to shift gears, as we often do on Mondays, from general civil matters to some misdemeanor criminal matters. At 10:30, we have this matter scheduled. People versus Tracy Ellen Wallers Penner. That's you.
Correct.
Here with your lawyer, Ms. Jordan Harden. Also present is Priscilla Walton, who prepared the pre-sentence report. And Abby Stoll is here from the prosecuting attorney's office. This is a charge of domestic violence or domestic assault. Defendant entered a plea in this matter by no contest on February 26th. The matter was set for sentencing today. The defendant called after the plea was entered and expressed concerns that she felt like she's not getting her side of the story told, felt her attorney wasn't helping her do that, and wasn't clear whether she wanted to go forward with her sentence. I took quite some time in taking this plea, but the law says that a defendant has the right to withdraw their plea prior to the sentence. And this court is supposed to construe that with great liberality, meaning the court is more likely to grant the motion than not. So we were quite taken aback when you did call, and we relayed that to Ms. Harden. Do you wish to withdraw your no contest plea, or do you wish me to go forward with the sentence here this morning?
I don't necessarily wish to withdraw it, but I would like to tell my side of the story.
Well, that's what today is for.
Okay. And
one of the problems is you can't plead no contest and then say, but I really didn't do it. When you plead no contest, you're sort of stuck with the factual basis. I can hear other related matters, but you can't plead guilty to drunk driving or plead no contest to drunk driving and then say I wasn't driving, or plead no contest and say, well, I drank after I got in the accident. If you plead no contest, the conviction stands. Do you understand?
Mm-hmm.
All right. I asked for a pre-sentence report in this matter, and Priscilla Walton has prepared it. She's new to this probation officer position, but she'd been with the office for a number of years, and she did a good job on her pre-sentence report. because I didn't know what to do with you. There's a great big purple elephant in the room, which is alcohol. You have a very substantial alcohol addiction problem. We worked on it when you were in sobriety court. We limped over the finish line. And somewhere between then and now, you've relapsed, and alcohol was behind this. And the irony of it is, this person who's the complainant in this case was the child in the car at the time of your drinking driving conviction a number of years ago. So I asked Priscilla to help us, and I'm not going down that path again. We struggled that whole probation. My current position, I believe she was trying to get over on us, that it wasn't all medical issues, that she was trying to dodge between the raindrops and was drinking while she was on that probation. But I'm not going to struggle with that every time she's deluded, because it was anguishing. And so she may not be able to do a probation, but there were some underlying issues of that.
Well, and she's also got some current medical issues with her thyroid that are having a significant impact on her health as well. So her main concern with the probation is not complying with the terms of the probation, is the medical issues creating complications, which could result in sanctions for her. Again, she's indicated that she wishes to relay some additional information about the incident to the court, and her frustration that she wasn't able to do that prior to today. But as I am a court of advised her, today's her ability to do that.
And that is the day for it. It's not the date of the arraignment. It's not the date of the plea. It's the date of the sentencing, where I will say, what do you want me to know? Now, if I gave you a test right now, what would it show? I said, this is the time at sentencing for you to tell me what you want me to know. I've had dozens of conversations with you over the years. What do you want me to know about this circumstance?
Well, Your Honor, how the morning had started was that I slept in but woke up and I could not find my cigarettes, which made me angry. Because in the past, Brielle has stolen and hid everything from my cigarettes to my purse to my car keys.
How old is she now?
She'll be 18 next week.
Okay.
To sorry, I'm feeling a little emotional.
That's fine.
She's went as far as to take all my prescription medication and drive around with it in her car, one of which was an opioid. And I told her she could get in big trouble for that. She just needed to stop. But she struggled with stopping. And she can get very mouthy. She thinks I was drunk. I had just switched from taking trazodone at night of 50 milligrams, and they doubled it on me to 100. So most mornings I wake up very groggy. Takes me a couple hours to get up and get going. But anyway, I hollered at her, where'd you put my cigarettes? And she got real lippy. So I walked back into my room and I sat down on the edge of the bed and I called Spectrum, and I was going to suspend her phone for a couple days just because I told her over and over that her mouth is going to be the death of her. And at that point, she comes screaming, running down the hall, and the Spectrum person could hear everything. And she grabbed my phone and we played tug of war, me to try to get it back. And I was just really trying to hang up the phone. But she managed to get it away from me. She took it and went out in the living room and sat down on the sofa. And my assault was walking out and I was behind her and I tugged on her hair once to get her attention. I'm here and I want my property back. That's when she decided she wanted to, her arms were flailing and she dug my neck all up. And I finally just let go of it and let her keep it. She went back to her room. I went in mine.
What did she have it?
My cell phone.
Oh, your cell phone. Okay.
Myself. She went in the room and shut the door and, she always, her and Steve had kept saying, just get out of the house. So I grabbed my purse and I left and went to the Hampton Inn. On the way, I did buy a pint of vodka. I only consumed it at the hotel in my room.
Let's assume for a minute her version that she didn't take your cigarettes. That you wake up, according to you, disoriented from your medication. You can't find your cigarettes and you're angry and you all assume that she took them. So she's minding her business and she says, you come in yelling at her, where's my smokes? And that's how the morning started. And she said, I didn't take your effing smokes. That's how low rent all that sounds. So then you decide, either in a moment of disorientation or a moment of clarity, you're going to call Spectrum and turn off her phone. And then she says to the Spectrum lady, my mom's real drunk. And she tells the police you were real drunk. So I don't know which is accurate, whether you were drunk, whether you were medicated, or stone cold sober. I think you were impaired either by something. And you're not supposed to mix medication with alcohol with those medications. So you started it. And now, over some dumb cigarettes, your daughter's living out of the home with an aunt, probably doing okay, making her way in the world. And the fact that you don't have any relationship with your daughters is nobody drinks straight vodka in a motel room at 9 o'clock in the morning unless they've got a serious substantial alcohol problem. And you have, Mr. Doherty, anything you want to tell me?
No, it's a good learning lesson for sure.
Yeah, sometimes the lessons are hard learned. You seem like a nice young man. Is another cowboy up case. We talked about those. There's hundreds of people in there and they're drinking out of pitchers and it's hard to tell who had what. It's also hard to get out of there, especially if you're headed north. Mr. Huff, anything you wish to add?
I mean, I would just note that it didn't take long or much prodding when I had a conversation with Mr. Doherty to venture over into the remorse. He was expressing remorse almost immediately, and then obviously,
The recommendation. We've been seeing lots of very high blood alcohol levels. I think Mr. Gibson wishes he had more clients like you. I'm going to order 1 day in jail credit, 1 day. I'm going to order a $300 fine, a $75 crime victims' rights fee, a $50 state minimum fee, a $100 screening fee, $150 probation oversight fee, And the police reimbursement, I believe, was 145. 145.
Your Honor, did you say oversight fee?
No.
Oh.
No oversight fee. I'm not placing him on a probation. This is simply a day in jail and fines and costs. How old are you?
24.
You may be the kind of guy that I will never see again. We get probably between 180 and 200 drug driving cases a year. And some of them are really bad. Also, several times a year, we have a traffic fatality. And some of them are like this. It's embarrassing. It's humiliating. It's expensive. It affects your driving privileges. And for many people, it's like, I don't ever want to do that again. I don't think you've got an incipient alcohol problem, but this is going to make you think about doing it before you drive. And if I never see you again, I guess this was a successful night in jail. When you're 50, you tell the story about when you were young and dumb and you spent a night in the St. Joe County Jail. Maybe that'll be the last one you ever do. $300 fine, $125 in state costs, a $100 screening fee, $150 attorney fee, which pays for part of it, and $145 cost, which is $820. All right. I'm going to order 90 days jail. Credit 1. Of the 90 days ordered, 89 are deferred. But if we have a probation violation, I'm just going to give you all 89 days. I don't want you to try to dodge between the raindrops again and beat the testing. It won't be as much testing as it was in sobriety court. But this is going to be a tough assignment for Priscilla. The fine is $0. There's a $75 crime victims' rights fee and a $50 state minimum fee, $150 attorney fee, probation oversight fee to $480. I'm putting you on a 12-month probation. At that time, we'll see what the prosecutor thinks about the deferral. Let's add that up.
Your Honor, my understanding in dealing with Ms. Canfield for the plea was that they were not willing to offer the deferral.
I understand, but maybe if she does a really good job on probation, maybe they'll reconsider. Won't hurt to ask, but the deferral is not part of this agreement because I can't do it unless the prosecutor consents.
I don't think she's eligible, Your Honor.
I don't think she has a previous DV, does she?
The child abuse.
Oh,
conviction
yeah,
was
maybe that
lodged.
did it. The
That's what
child,
Ms. Canfield
Yeah.
advised.
yep. Thank you, Abby. Yeah, the child in the car, that means you're not eligible, so I guess it won't matter. Even if they did agree to it, you're not eligible for it. You're to pay for the class. That's $755. Have a PR bond. Anger management, substance abuse, counseling, no assault or threatening behavior, alcohol and drug testing as directed. I have no bond. How long will it take you to pay $820?
Can I pay today?
Yeah, you can pay it now. and this matter is over and done with, you're gonna get a notice that your license is suspended, restricted. You'll be able to drive back and forth to work. In the course of work, if you do treatment, medical appointments, school, other limited purposes, doesn't give you the authority to drive to the movies or the golf course, at least for a period of time. But it will allow you to get back and forth to work. We have done some of these, but at least in one of the things I mentioned, we've become desensitized to how high the blood alcohol levels are. 2.23, 2.27, 3.2. Many cases in the twos. But even without that, a 0.16, 2 times the legal limit, we tend to think, well, people aren't that drunk. They're real good and drunk at a 0.14 or 0.16. And people that have blood alcohols in the range of the twos and certainly the threes have developed a tolerance to alcohol, which allows them to drink that much. Most people can't get to a 2.23. You have to take practice. You get sick and or pass out. I don't want to try it. When they used to send the officers to breathalyzer school or data master school, they would have to get drunk in the line of duty. The officers would have to drink enough to take a breathalyzer. There probably were some exceptions for religious or other reasons, but they would get drunk and then take a breath test and then realize how drunk they really were. We did an experiment in the prosecutor's office many, many years ago. We videotaped it where one of the assistant prosecutors drank a pint of peppermint schnapps, a pint, and drank that, and then later took a breath test. He was drunk. He was kind of funny, but he was only a 0.08. That video is probably preserved somewhere. Anyway, Mr. Doherty, I think you're going to be all right. This would be a learning experience, and that's how you reported it. I'm going to have the bailiff take you out to the court office. You can pay that fine, and you're good to go. Thank you, Mr. Gibson.
Two defendants walked into the same courtroom on the same Monday morning in March. Same judge, same room, different stories. The first was 24 years old, first offense. He left a bar called Cowboy Up on New Year's Day and made a decision he knew immediately was a mistake. He said 4 words to the judge. "It's a good learning lesson." He meant it. The judge believed him. He paid $820 on the spot and walked out. The second had been in that courtroom before, many times. The judge had known her for over 12 years, through sobriety court, through a prior DUI, through a relapse, and now through a domestic assault charge that began, by her own account, because she could not find her cigarettes. She tried to tell the judge she was the real victim. She brought a photo of her scratched neck. She blamed her daughter, her thyroid, her medication, her ex. The judge listened to all of it. And then he said, "Over some dumb cigarettes, your daughter's living out of the home, and that's on you." That is the gap between those two defendants. Not age, not even the crime. It is accountability. One of them walked in, held his hands up, and said this was on me. The other spent 30 minutes explaining why it was on everyone else. The judge gave both of them exactly what they showed him they deserved. One walked out in 20 minutes. The other left with 89 days of jail hanging over her head like a loaded question mark. This is what a decade of choices looks like in real time. And this judge has seen it more times than he can count. If you found this case as eye-opening as we did, hit that like button. Drop your thoughts in the comments. And subscribe for more real courtroom breakdowns, because justice never gets old.